As the opposition has always made clear, we support a corruption commission consistent with our strong stand against stamping out, a strong stand against corruption. People who break the law should face the law. And it was, of course, the coalition which first introduced Australia's first ICAC in New South Wales back in 1988. While we support the establishment of a National Anti-Corruption Commission, as we've heard in this debate, it is absolutely critical to get it right. The bill, after all, does confer extraordinary powers on the Commission and also applies to a very broad range of Australians, not just parliamentarians and public servants here in Canberra, but a wide range of people working for the Australian Defence Force, the Australian Federal Police, agencies such as the National Disability Insurance Agency and aged care workers, as well as any contractor or subcontractor or any person exercising a power under a law of the Commonwealth. However, as we've also heard in this debate, conveniently, somehow, it doesn't apply to union officials exercising a power under a law of the Commonwealth, and I'll return to that point in a moment. So with such a broad application and all the powers of a Royal Commission, it's critical that we get this bill right. The bill isn't perfect, and I have to say there's been a lot of very good work in this parliament addressing a range of shortfalls, including by the Parliamentary Joint Select Committee on the National Anti-Corruption Commission legislation, which made 6 consensus recommendations. There have been many other additional comments from coalition members and senators, coalition members of that particular committee, as well as coalition members and senators across the board, seeking to ensure that the bill gets the balance right between stamping out corruption and protecting the rights of everyday people brought before it. Extensive recommendations from the Senate Committee on the Scrutiny of Bills highlighting the concerns around a lack of specific identification of things like definitions and the use of coercive powers without adequate safeguards. They've all been issues that have been raised through the committee process, as well, of course, as for the recommendations from the Parliamentary Joint Committee on Human Rights, which noted concerns about the use of gag orders and the harm that those gag orders can cause, particularly to the mental health of people brought before the Commission, as well as the broad use of contempt offences. The Coalition has gone about engaging with the government, with the crossbench, and through the committee process in this parliament with good faith. That said, of course, there are a number of amendments that the Coalition is proposing. The first one is that we'll introduce some amendments concerning not allowing union members to receive an exemption under the bill. So as we've heard in this debate, a disinfectant is the best form of sunlight, and if the government is going to talk a big game on integrity, that goes out the window when unions are exempted from the operation of the Commission. My office is in Geelong, where the NDIS has its national headquarters. Just imagine the unfairness, the lack of integrity in passing legislation which gives the Commission the power to call any NDIS worker with the agency, but not a union official exercising Commonwealth powers. That category of persons is let off scot-free. So if it's good enough for NDIS contractors, if it's good enough for the aged care workers, and for members of our Defence Force, it should be good enough for union officials. We just cannot have a bill passed which does a special deal for unions. The Coalition is proposing a number of other amendments, including introducing amendments supported by eminent experts in this field, including the Law Council of Australia, the Queensland Council of Civil Liberties and the South Australian Bar Association, that the power to decide a public hearing not be vested in the Commissioner alone. We think it's really important that there are all the appropriate safeguards in this bill, including on this issue. It's critical that it's not just the Commissioner who decides to commence a public hearing. We are concerned that that vests far too much power in one single person. This power needs to be shared between the Commissioner and a Deputy Commissioner to ensure, again, greater integrity, transparency and proper governance. We also think it should be compulsory, not optional, for the Commissioner to consider factors including whether confidential information is involved, whether there would be unfair prejudice to a person's reputation, or whether a person giving evidence has a particular vulnerability, such as being under direct instruction or control of another person, in determining whether a public hearing should be held. This was supported by the Queensland Law Society, the Australian Human Rights Commission and the Australia Institute. Again, we want to see these changes in the bill to make sure that we have every possible safeguard. The Commission should also be required to only commence an inquiry into matters which took place prior to the establishment of the Commission, if it is in the public interest for them to do so. So there must be a strong public interest test when determining whether a retrospective inquiry will be held. All decisions of the Commission should be subject to review under the ADJR Act. Significant aspects of the bill are not subject to this review, and this was a very strong recommendation made by the Law Council of Australia, and of course that is one that we strongly support. The Commission has the power to impose non-disclosure orders or gag orders on people which prevent them from disclosing that they have appeared before the Commission. This is a very contentious issue. Of course, we think it's essential that there be very limited exceptions to this in the interest of the mental health of the people who come before the Commission. People should be able to make a disclosure to an immediate family member, as long as they're not also a person of interest, a medical professional and a mental health professional. It's critical that we do not put people in this situation where they feel they have nowhere to turn. There was a shocking case in Victoria. A friend of mine who appeared before IBAC, and tragically she committed suicide. No findings were made against her. We don't know all the inner details of what led to her death, other than we do know that she was absolutely traumatised by what she was going through. And so when people are put under this extreme pressure, it is absolutely critical they have the supports that they need to get through what can be obviously a very difficult and traumatic set of circumstances. And I do say that there have been, from all reports, a number of people who have committed suicide, who have been before various anti-corruption commissions as a result of the trauma and of the grief of what they have confronted. We're also, as an opposition, concerned about the privilege against self-incrimination and legal professional privilege. We are proposing to introduce amendments which ensure that these privileges are only granted when absolutely necessary, because again this imposes very significant imposts on fundamental rights. Another amendment supported by the Law Council. Geoffrey Watson SC, as we've heard in this debate, supports an amendment that investigations not go on indefinitely. Our amendment will propose a 12-month time limit on investigations. Time limits are also critical to justice. People cannot come before these anti-corruption commissions indefinitely, put their lives on hold year in, year out without any sense of certainty as to the length of an investigation. We also think it's absolutely critical that there is bipartisanship in the creation of a new body like the National Anti-Corruption Commission. That's why it's important, very important, that there is a 3/4 majority of the Parliamentary Committee overseeing the Commission in relation to the appointments of the Commissioner and the Inspector. Without the support of all sides of government, the Commission risks losing the trusts of the public. We don't want to face any sort of risk that any appointment like this, as important as these appointments are, could be politicised in any way. I emphasise this is a very strong integrity measure. This bill must stand the test of time, not just in relation to this government, but future governments. And like excluding the unions, this bill cannot be clouded by questions of integrity, and that's why this amendment must be supported also. Thank you.